need to run your companies and your departments with a lot of peace of mind. So all that being said, I have the great privilege of introducing our trainers today. Today we have two trainers. So we have Mary Bradford, who is our Director of Human Resources, and Juliana Gabriel, who is our Human Resources Compliance Director. I know we have a ton to go over and we want to get to everyone's questions. So ladies, it's all yours.
Great. Thank you so much, Anna, and welcome everyone. My name is Mary. I'm going to be the first trainer for the first half of today's class, and then Juliana will take over midway through, but she will be in that Q&A box, as Anna mentioned, so please do pose any questions that you have there. We do have a lot of content and information to get to, and so we're happy to help you with your questions. So again, you can put those in the Q&A box, but of course, if you think of something later or something you just rather ask offline, then that's what you've got the hotline for. And the slide I have up now is the Riverside County Workforce Development Center HR hotline that we power here at CEA. So you can give the hotline a call Monday through Friday, 8 to 5, and your number is 888-201-5950. So you can give us a call to ask any questions on today's presentation or any other HR issue that you have. If you have questions on breaks and lunches, harassment prevention, employee handbooks in general, that's the hotline number to call. But we do ask that you call your direct Riverside County number, the number that's on the screen, so you can take a screenshot of that. So you have that handy. You will see our main 800 number on all of the other slides, but we do ask that you call the Riverside hotline number directly, and then we'll know where you are calling from. Real quick legal disclaimer here that we'd like to remind everybody that CEA is not a law firm. So when you call the HR hotline, and I know we have some CEA members on with us today as well, you have to keep in mind that we're not giving you legal advice. We're providing you with information and resources and options, but ultimately all of those decisions are up to you. And we always do recommend that you consult with an attorney anytime you have a matter of legal significance for you and your company, just in case you do need to get an official legal opinion. So do keep that in mind as we're going through today, even though Juliana and I will be talking about laws and regulations and guidelines. Keep in mind, we're not giving you legal advice today. And then you might be thinking, okay, well, I know about this HR hotline, but who is CEA? Well, that's the company that we work for, and that is the California Employers Association. And our job is to try to make your life a little easier, especially when it comes to the first part of the year, when there are all these new changes with labor law updates and new laws, and we're still trying to figure some of them out because they don't always give us all of the information we need. That's what we're here to do. We're trying to gather up all that information and give it to you in a easy to digest format, so you don't have to worry about sitting there and reading rules and regulations and new bills. That is our job. Honestly, it's Juliana's job, and she's very good at it. But we're here to just bring you that peace of mind and help you with those HR issues. And you might find that you need a little more help above and beyond the HR hotline. And at the very end, we'll talk just a little bit about if you need extra help and you might need an individual CEA membership, or if you want to have full access to our website with all of our forms and toolkits. We'll be talking about that through the presentation, but we do have a lot of great resources. So if you need some extra HR help, of course, you've got the hotline you can call, but if you need a little additional assistance, we can help you out with that as well. So here's what we're going to cover. And we always do like to say today is January 30th at noon. The information we're giving to you is up to date as of right now, to the best of our knowledge, but it is subject to change. So keep that in mind. They are constantly changing, updating, reinterpreting guidelines. So sometimes this information will change from one day to the next. But what we're going to talk about today is the new paid sick leave expansion, that is PSL. We're going to talk about some other leave and time off provisions when it comes to reproductive loss that we have in California now. We're of course going to spend some time on minimum wage and exempt salary increases, because I know you're dealing with those every day, trying to make sure you're paying your employees properly. We're also going to talk about a new law that's coming into play this summer, and that is having a workplace violence prevention plan. So I'll give you a little bit of an overview on that. And then I'm going to turn it over to Juliana. She's going to talk about cannabis use rights, some other regulatory changes that are with some agencies, specifically the NLRB, and then a couple of FAQs and more. So we've got a lot to cover. Now I'm going to go ahead and jump into it. The number one thing that we can tell you, if you take anything away from our next hour and a half together, is plan on updating your 2024 employee handbook. There have been so many changes over the past year, but this year specifically, there's some language that you really want to make sure you have up to date in your handbook. Now, when we're going to talk about paid sick leave here in just a moment, remember that's a policy you're required to have in your handbook, so you want to make sure that is up to date as possible. But there's also just some employee-friendly language when it comes to the NLRB, and Juliana will talk about that. But we do want to make sure your handbook is always California compliant. So kind of avoid the temptation of just downloading a random handbook from the internet, borrowing a handbook from somebody else. You are in a much better place if you get a California compliant, up-to-date handbook. And we do have one that's available to you on our CEA store that you can purchase. It'll be sent directly to you. Everything is written in it and up to date for 2024. You just have to do a little bit of customization and in regards to your own vacation benefit, holidays, etc. But all of the other policies are there and written for you. So we really encourage you, make sure you've got an up-to-date handbook. If you use ours, fantastic. If you work with an attorney, that's great, but just make sure you've got that up-to-date handbook because it really can save you a lot of hassle later on. So you make sure you're compliant with California. So let's start into our expansion talk when it comes to some leave of absences, and we're going to start with paid sick leave. Now, the first thing I like to talk about paid sick leave, because I think when people first heard about this, they thought it was a completely new law. It was really, really different, or it was difficult to interpret. And it's really not that crazy. So let me just kind of say to you, think of it as an expansion. It's just an increase to our already existing paid sick leave law that's been on the books for almost 10 years now, went into effect in 2015. So what paid sick leave is this year is it's expanded. It's bigger than it was before. So now you're going to need to give your employees, in the past, you had to give them at least 3 days or 24 hours, but now that has increased. And now you need to give your employees 5 days or 40 hours of paid sick leave each year. Now, you can still use your same accrual method if you're using that, where you give your employees 1 hour of paid sick leave for every 30 hours that they work, or you can still use your lump sum method, where perhaps you just dump 40 hours into a paid sick leave bucket. In the past, you would have just put 24 hours in there, but now you need to put 40 hours into that paid sick leave bucket for your employees. Now, the one change was, again, because it's an expansion, if you are using that accrual method, in the past, you used to be able to cap that accrual at 48 hours, but now we need to increase that, and you can cap that accrual at 80 hours. So your employees, again, would accrue 1 hour for every 30 hours that they work. You can cap that accrual at 80 hours. But keep in mind, you can still limit your employees to only using 40 hours per year. So even if they can accrue more, you can still say everybody only is allowed to use up to 40 hours per year. So there's no change to the accrual except the amount of time you have to allow your employees to accrue. It's still at the 1 hour for every 30. So the thing that is throwing people off a little bit is if you are using an alternative accrual method. So say, for example, you have a paid time off plan where you combine your vacation and your sick plan together. So there are some new requirements if you do that. If you use an alternative accrual method, you have to guarantee that your employees have 24 hours by the 120th calendar day of employment, and they have to have 40 hours of paid sick leave by the 200th calendar day. Now, again, this is only if you're using an alternative accrual method. If you're using the state standard method of 1 hour for every 30, you don't have to meet these guidelines. It's only if you're doing a different accrual method. So your employee has to earn 1.5 hours every week, regardless of the number of hours that they work. So by the 200th day, they would then have 42 hours of paid sick leave, and they can use up to 40 hours of paid sick leave again in that entire year. So if you're using an alternative accrual method, keep in mind you can't go with based on hours worked if they're not accruing at least about 1.5 hours per week. So check your accruals on that and be cautious with that. Now, this is something that we've been working with a lot of hotline callers and a lot of members on. A lot of employers are choosing to break apart their plan. So instead of having a combined paid time off plan, they're now having a standalone vacation plan and a standalone paid sick leave plan. Just makes it a little easier to manage, because remember, if you have a paid time off plan that includes your paid sick leave, basically your entire PTO plan is subject to paid sick leave requirements, and it can just get a little more difficult to manage. So that's why we encourage you to take a look at perhaps separating those out, and give us a call on the hotline. We'd be happy to talk with kind of the pros and cons and how you need to go about doing that. So here's a question we've been getting a lot. We use the lump sum approach based on anniversary date. We previously gave 3 days and 24 hours on that employee's anniversary date, which is usually their hire date. So can we wait until each employee's anniversary date in 2024 to reset it to 5 days and 40 hours? So for example, if you had hired somebody April of last year, could you wait until April of this year to give them 40 hours? So the answer is no. You've got a couple of options here. So you can either give them 2 additional days or 16 hours as of January 1st, 2024, and then give them their additional 24 hours on April 1st, if that's their hire date. But we recommend, it might be a little easier for you if you just reset everybody as of January 1st. And so everybody as of January 1st, that just becomes their new anniversary year. And then you just deposit those 40 hours into their paid sick leave bucket. And that's your new anniversary date for every year moving forward. So, and again, you can give us a call if you kind of want to talk through a couple of these different scenarios, but there are some options. And again, I always say, try to do whatever makes your life a little easier and makes it less of an administrative burden for you as well. So how am I going to address these new paid sick leave requirements? Well, here's the first thing. You're going to update your policy. So your policy probably says we give you 3 days or 24 hours. So you need to make sure it says that we give you 5 days or 40 hours. Now, another question you might be saying is, well, we have employees that work 9-hour days or 10-hour days. Perhaps you're under an alternative work week schedule. Keep in mind, it's 5 days or 40 hours, whichever is the most generous benefit for your employees. So if your employees work on average 10-hour days, then they will actually be getting 50 hours of paid sick leave, because 1 day for them is 10 hours of work. So for those of you under an alternative work week schedule, I'm sure you're very familiar with that, but just keep that in mind. We always need to ensure that we're giving employees the more generous benefit. So you're going to update your policy. You're going to update your wage statements. So on their paychecks, it needs to make sure it's reflecting the correct information, and there is an update to the poster. Another reminder, as I mentioned before, make sure you've got a 2024 handbook that's up to date. Make sure you've got a 2024 poster that is up to date, a California and federal all-in-one labor law poster. You can also purchase those from our site if you need that under our CEA store. We have those for you available for other states as well as California. English is up to date. We are still waiting on some Spanish posters to be up to date. As soon as those are up to date, though, we'll get those right out to you. But you purchasing a poster and having receipt of purchase shows that you have one on the way and that you are compliant, even if there's a delay in the state releasing a poster, so we can get everything up to date. So another question to ask yourself, are you going to change your vacation accrual or paid holidays to maybe offset the increase that you're going to have with new paid sick leave? Yes, you are allowed to do that. Remember, vacation and holiday pay is at the discretion of the employer. So if you say, well, you know what, we're increasing our paid sick leave by 2 days and we're going to cut 1 or 2 holidays, you are allowed to do that. You do want to give your employees as much notice as possible when you do that. You do want to give everyone a updated wage theft notice, and everyone, I'm sorry, your hourly employees, your non-exempt employees. That will tell them what the new rate is for their paid sick leave. You might remember that form. That's another form that you give everyone at hire, where it talks about workers' comp, it talks about what rate they're making, it talks about the paid sick leave. So we advise that you provide your employees with a new copy of that wage theft notice. And of course, you need to review your local sick leave ordinances. Being in Southern California, as you probably know, there's lots of cities in Southern California, as well as the Bay Area and Northern California, that have their own paid sick leave requirements. So this change at the state level really brought it in line with most cities, but you of course always want to check to find out where your employees are working so you can make sure that you are as up to date and providing the best paid sick leave benefit for them. And I see Juliana is back. We probably have some questions on paid sick leave. What do we have going on, Julie?
Yes, so we got a great question about if somebody has an alternative work week, such as a 4-10 schedule. And as you noted, it's the equivalent of 5 days or 40 hours. So do you want to explain kind of how that would bump somebody up to the 50 hours
Sure.
in that case?
Yeah, absolutely. So if an employee is working 10 hours per day, that's their work day. That means when you're looking at how much paid sick leave time we want to give them, they get 5 days or 40 hours. So for them, a day is a 10-hour day. That means we actually need to give them 5 days at 10 hours each. So they're going to get 50 hours of paid sick leave. So you could have some employees who are at a higher level of paid sick leave just based on what their work days are.
And then Mary, you already explained it, but I know that we get a lot of questions on this. So there's some questions about whether or when you have to meet that requirement of the 120th day and the 200th day having a certain number of hours. And so I just want to reiterate that if you're using the default accrual method of 1 hour for every 30 hours worked, you don't have to worry about those rules. And so it might be best to have your part-time employees on that default accrual method if they're not earning that much time. But I know we get a lot of questions about that. With a PTO program, you likely will have to worry about that.
Right. Yeah, that's a really good point. And another thing for everyone to remember is you can have different plans. So for your full-time employees, if you want to do just the lump sum and you just dump that 40 hours in a bucket for them, fantastic. But then for your part-time employees, maybe you just go with the accrual of 1 hour for every 30 hours. You're allowed to do that. It's perfectly fine. You just want to make sure you have a clearly written policy that explains who gets what, so it's clear for your employees too.
Yeah, great point. All right, I'll go back to the Q&A. Thank you.
Okay. Thanks so much. Good questions, everybody. All right, let's talk about another leave. As you all know, last year the state, introduced a bereavement leave, unpaid bereavement leave. There was a little bit of confusion when it talked about who was covered and who that benefit was for. And so they clarified this year by having kind of a separate breakout leave for reproductive loss. So this applies if you have 5 or more employees that you need to provide 5 days of bereavement leave for a reproductive loss event. Now that is defined as a failed adoption, failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction. So if you have an employee who's going through that, perhaps they're trying to get a child placed with them and that doesn't work, then they can use this reproductive loss event. Now, it's a little different than bereavement leave. Bereavement just gives you those 5 days for your employees, again, unpaid leave. This gives you up to 20 days that an employee can take for a reproductive loss bereavement leave. This is also unpaid, just as bereavement is. But a little bit of a difference here with this leave is that you cannot request certifying documentation. So as a reminder, when it comes to bereavement leave, you can. So an employee says, I need to take time off, my brother passed away. And so you can say, okay, well, you can, please provide us with a copy of an obituary or a copy of the program for the service. You're allowed to request that. When it comes to reproductive loss, you are not allowed to request any sort of documentation. Also, with bereavement leave, it is unpaid, but you as an employer can choose to pay some days if you would like to. Again, you want to make sure your policy is very clear that you provide, maybe it's 2 days of paid bereavement leave or 3 days of paid bereavement leave. You can have that for bereavement. It's again not required to have that for reproductive loss. So you could have your regular bereavement provide 2 days of paid leave if you would like, and you could say reproductive loss is unpaid. So there's a little bit of flexibility with these two plans, but again, you want to make sure you have a clearly written policy that spells it out so employees understand what they're entitled to. A couple of rules when it comes to this reproductive loss leave. The employee needs to use that leave within 3 months of the event. Now, if for some reason, if they are utilizing CFRA or FEMLA, this runs separately. So it does not run concurrently at the same time. And also the days do not need to be consecutive. So you don't say to an employee, well, you can have 5 days, but you have to take them all at once, just like bereavement. You might have an employee that needs to take 2 days this week, and then they need to take 3 days a week or two later. It can be broken up that way. Again, this is unpaid, but the employees can use any accrued and available time. They can use sick leave or they can use their vacation time if you provide that. So do, again, make sure this is another policy update. You're going to want to make sure you include that information in your 2024 handbook. All right, let's leave leaves behind and let's start talking about wage and hour, which I know is something you do have to worry about all the time. You're keeping an eye on this. So in years past, you might have remembered that the state would kind of break it down what you needed to pay employees based on employer size. So if you had 26 or more employees, you were at this rate, or if you had 25 or fewer, you're at this rate. So that is not really in effect for statewide anymore. What you're looking at now is just a minimum hourly rate that you need to pay all of your employees, which is $16 per hour. Now, the reason we have to pay attention to what the state minimum wage is because that affects what the exempt salary, minimum salary requirements are. So for an exempt employee, so that means a exempt salaried employee, they need to be making at least $66,560 per year. So you might have some exempt employees that are below that right now. So as of January 1st, that's what they're supposed to be making. If you think I can't make that adjustment, I'm going to need to move them down to a non-exempt employee, you can absolutely do that. That is allowed in California. And in fact, all employees pretty much default to being a non-exempt hourly employee unless you, as the employer, show they should be something else. So when in doubt, have them as a non-exempt employee. That's perfectly fine. But if somebody's been exempt, if they've been a salaried employee for a while, it can be a little tricky to transition them back to a non-exempt hourly employee. So you might need to do a little coaching, a little retraining, remind them about breaks and meal periods, and of course, they'll be paid for overtime as well. So we have a couple of tips for this, since a lot of employers have been dealing with this big increase. It was quite a big jump from last year for smaller employers. So you can use that bit.ly link that we have there to access that, and it'll give you some tips and tricks on that. Now, the other thing to keep in mind, just as we were discussing paid sick leave, we've got a couple of cities that have their own guidelines. Well, a lot more cities in California have their own local minimum wage laws. So over 40 cities are kind of doing their own thing. Again, many in Southern California, many in the Bay Area. So of course, you want to make sure you know where your employees are working at all times, because if you have an employee who is perhaps working from home a couple days a week, or maybe they're working at one of your locations that's in a different city, you need to find out what that minimum wage is, because of course we always have to be paying minimum wage where that employee is physically working. So if your employee is working in a city that has higher minimum wage requirements, make sure that you are paying that higher minimum wage. So again, we've got another cheat sheet for you there. There's another bit.ly link. You can put that into your browser and that'll bring it up for you. We do have a couple of changes with some industry specific wages. I'll talk about that just in a bit. But the other thing I like to remind everybody, because you think, oh my gosh, there's so many different minimum wages in other cities, does that affect the exempt salary? So in general, it does not. We'll show you an example of where it most likely will. But in general, the state just defaults to the state minimum wage to determine what the salary exempt minimum requirement is. So if you have employees that are in a city that has a much higher wage, North Hollywood, for example, or Pasadena, you still have to just make sure they are meeting the state exempt salary requirement. So again, that's $66,560 is the minimum salary requirement for any exempt employee, even if they're working in a city that has a much higher minimum wage. So you still just have to look at that state requirement. But keep in mind, it's a lot more than just their salary. You have to make sure that they meet that salaries test as well as that duties test. So they need to fall into that professional, that managerial, or that administrative exemption in order to be truly a salary exempt employee. Now, another area where we need to remember to pay our employees, I actually had several questions on the hotline on this yesterday. People must be out and about driving to go pick up things. But anytime an employee is using their personal vehicle for business use, so if we say to somebody, I need you to go swing by the bank and make this deposit for us, or can you go pick up Starbucks for everybody? You're asking an employee to use their personal vehicle, which means we need to reimburse them for that cost. Now, every year the IRS sets a rate that they say covers the cost of gasoline and insurance, wear and tear on an individual's vehicle. And for 2024, they're saying it is 67 cents a mile. So we always advise that you pay that IRS rate, because when you do that, you're paying what the IRS says you as an employer need to pay an employee when they're using their personal vehicle. If you pay less than that, there's the potential that you could be on the hook for some cost. So if you are only paying an employee, for example, 50 cents a mile when they're driving for you and they get a flat tire, they could have a pretty good argument that you as an employer aren't paying enough and you need to pay for the cost of getting them a new tire. So we always advise that you pay that IRS rate. It's much safer for you. The other thing to keep in mind is that you need to pay your hourly, your non-exempt employees anytime that they are driving for you. So if they drive to the bank, even if it's down the street or a mile or two away, you still need to pay them for that mileage. Now, of course, our exempt employees, they are paid a flat salary, so they don't receive extra pay, but you do need to make sure that you're reimbursing their mileage as well. So anytime non-exempt or exempt employee is traveling for you in their personal vehicle, you're reimbursing them that mileage rate for any mileage that they drive. Their non-exempt employees need to be on the time or on their time clock as well when they're traveling for you. So here are a couple of carve-outs to that minimum wage requirement that I mentioned before. Physicians and computer professional salaries are kind of in their own little bucket. In order for a physician or surgeon has to be paid at least $101.22 an hour. And computer software professionals have to be paid $55.58 per hour, which is the annual equivalent of $115,763.35 per year. So if they are not making at least that, then they are going to be considered a non-exempt employee. So again, if that's one of the industries that you're in, double check on that. Keep in mind, for someone to be classified as an exempt computer software professional, again, this is a very high level position, as exempt positions are, and that's going to be a director of IT or a webmaster, or again, a high level position. So make sure you've got those individuals classified correctly as well. Another kind of slide here on reimbursement, and this is specifically about remote work from home reimbursement. So remember, anytime you as an employer are telling your employee to do something, so if you say, we want you to work from home 3 days a week, or you're really encouraging employees to work from home, you need to cover some of those work from home costs. So that could include the cost of their internet, potentially some utility cost, office equipment, if they need a laptop to do their job, if they need a printer, if they need paper and ink supplies, and then the personal mobile phone. Those are kind of the most popular ones. But anytime an employee needs something at their home to do their job for you, you need to make sure you're providing it, or you're providing a reimbursement for it. Now, the state hasn't come out with some clear figures on what that reimbursement needs to be, so they advise employers to do a reasonable percentage of the total cost. And this is really something that you as a business need to decide for your area and for what your employees are doing, what is reasonable. So what you can do is take a percentage. So if your employees work from home 100% of the time and their monthly internet bill is $60 a month, then half of the time they're working for you, then perhaps you reimburse $30 of their internet costs. Same thing for a cell phone bill. If they are on their mobile phone constantly for you for work, probably makes sense to reimburse them about half the cost. If they just need to use their mobile phone to log into your time card system twice a day or 4 times a day, then you probably don't need to reimburse them as much. So what you want to do is come up with what you feel is a reasonable percentage or reasonable amount. Have an agreement in place with your employee. We recommend you have a signed agreement and then tell them if they feel that that is not reasonable, that they need to contact you, and then they can provide some documentation or backup as to why they feel they need a little bit more. So a couple of to-dos for you here. Check those county and city minimum wage laws, and of course for paid sick leave as well. Minimum wage poster updates, those are out there. We're still waiting again. I think the Spanish is the minimum wage we're waiting on as well. But keep an eye out for poster updates during the year. They do sometimes make changes. That's why it's a good reminder. Make sure that you are on our email list and you're getting our updates in our newsletter. We'll certainly let you know when there's new posters out there. If you do have employees that work remotely, we really advise have a written agreement in place that talks about what they're expected to do when they are working remotely, where their office is based or where their location is considered their office location, and also set out your reimbursement policy so everyone's on the same page there. And of course, reimburse our employees for that business mileage when they travel for you. And our non-exempt employees, make sure that they are being compensated correctly and on the clock for any of that time. And then just keep an eye out for minimum wage and salary increases. A lot of minimum wages go up January 1st, as the state does, but a lot of cities have April 1st minimum wage increases as well as July 1st increases. I still don't think we have any October 1st increases, but you know what, we kind of like to keep it fresh and exciting here in California, and I wouldn't be surprised if we have some of those changes soon. All right, so let's start talking about some safety updates in the workplace. And this is one, here's the good news, everyone can just like take a deep breath, because I know I've been giving you a lot of info about what you have to worry about right now. Here's one that you've got a couple of months before you need to lose sleep over it. This is the Workplace Violence Prevention Plan that employers are going to be required to put into place. Now, not until July 1st. So again, we've got a couple of months to work out some of the issues, which I'll tell you about here in just a moment. But what this will do for you as a business is you're going to establish this workplace violence prevention plan, and you are going to be responsible for implementing it. You're also going to be responsible for training your employees on it. So by July 1st, you're going to need to have a plan, and that's when you are going to want to conduct your training. You are also going to need to conduct that training annually. So this is something as opposed to, for example, harassment prevention, where you just have to train every other year. You will want to add this to your annual training calendar. So as a reminder, when you have a new hire who starts for you, we recommend to get all of that training out of the way as quickly as possible so you can get them working and get them under all of your policies as quickly as possible. So as part of that new hire orientation, you give them all their new hire paperwork, you have them do their harassment prevention training, and now as of July 1st, you'll have them do the workplace violence prevention plan training as well. Now, there are a couple of exceptions to this, and perhaps some of you will fall into this. Teleworking employees will not need to have a workplace violence prevention plan. If there is a location or a business that has fewer than 10 employees at any given time and not accessible to the public, we don't have a full definition on what that means quite yet. But if you have fewer than 10 employees, not accessible to the public, and a compliant IIPP, which is your injury illness prevention plan, then you could be exempt from this. Also, healthcare facilities, Department of Correction and Rehab, and law enforcement agencies already have their own requirements in place when it comes to workplace violence. So they are already doing this, which is if you Google or take a look and try to find a workplace violence prevention plan, you might say, well, I found a bunch of them out on the internet. Problem is they're probably just for one of these industries that already have to have them in place. We don't have a template yet for just kind of a general business workplace violence prevention plan, but we will keep you up to date on that as we get closer to having one that you can put in place. Now, as I mentioned, that IIPP, again, injury illness prevention plan. So that's something you should already have in place for your business. You can incorporate this workplace violence plan into that. We would actually advise you keep it separate as a standalone document, just because it's easier to manage when you have these things separate in case there are changes to one. You don't want to have to worry about changing all of them. When it comes to what this plan will have to do, you as a business will need to do inspections on your workplace to make sure you are compliant with what your workplace violence prevention plan is all about. You will also need to make sure you are doing investigations when there is a hazard, when there is some sort of incident, and just periodically throughout the year. You will begin recording incidents on a violent incident log when you do an investigation. And for those of you that are CEA members, we already have a sample up for you. You can access that on our website. Just make sure you're logged in so you can see what that looks like. You're also going to need to hold on to those records for at least 5 years of identification of a workplace issue, investigation, evaluation, correction, etc. So you've got some record retention requirements there. When it comes to training, you're going to want to make sure you hold on to those for at least a year. Now, here's where it gets a little tricky. So as I mentioned, this was put into place and it's effective July 1st. The little issue that we're having is Cal OSHA isn't required to propose standards for a workplace violence prevention plan until 2025 or until 2026 when the standard board would adopt those standards. So we don't have a lot of clear direction on this, which is why we're kind of just giving you some general information. We hope in the next couple of months we will get some more clarity on what you as an employer need to have on the plan. We, of course, will keep you up to date on that. But here's kind of an idea of what these incidents might be. And you might be thinking, well, this probably won't happen in my workplace. But when I show you what some of these examples are, you might actually realize, oh, maybe we could have an issue. So this could be somebody who's threatening an attack with or without a weapon. This could be some sort of assault or verbal, physical, sexual conduct. Think about, again, employees' complaints of somebody saying, I was attacked by someone, either physically or with a weapon, something along those lines, or there was a fight that occurred between two employees, or this could be an animal attack. So for those of you that have employees that might work out in the outdoors, if you're a landscaper out in the field, I noticed we had several golf courses. There might be animals out on the golf course that your employees might come into contact with. So that would be a recordable incident. So we'll have some more information for you as this becomes available, but a couple of to-dos, just put it on your radar that this is something you'll need to be thinking about as we start to hit the middle of the year. So again, July 1st is the deadline for that. What you want to do is figure out who's going to be my safety person. This could be whoever's in charge of your IIPP. Perhaps you have just nominated yourself to take care of this task as well, but you do want to figure out who's going to be responsible for putting this in place. Again, you're going to train your employees July 1st. You're going to set this up as an annual training, and then just start to prepare and think about how you'll be putting this plan together. There will most likely be an opportunity for your employees to provide input on what they think could be improved in the workplace. So you'll be taking that into consideration. Again, you're going to hold on to some record retentions a little longer, 5 years for your record retention on this one, where most employee records are about 4 years. But for these, you're going to hold on to them for 5 years. And of course, you're going to keep copies of all that training in case you ever need to prove and show that you took care of all the training requirements that were needed. All right, let's talk about a couple of COVID things here. And I'm happy to tell you there's really only one slide that we have to worry about this. But you might have heard January 9th, so just a couple of weeks ago, the CDPH, that is the California Department of Public Health, came out with some brand new rules. And they were rather quiet, I have to say, about announcing these new rules, because it was actually probably a relief to a lot of you who are trying to run your business. And it was certainly good news as far as the exclusion rules when you need to keep employees away from the workplace. As you might recall, it used to be 5 days anytime an employee would test positive. They had to be excluded from the workplace for 5 days. All of those rules are gone now. So there are new guidelines that say if an employee is not symptomatic and they are well enough to come to work, they are fever-free, and you haven't been using fever reduction medicine, they can return to work now. So you don't have to worry about that 5-day exclusion period, which I know is a lot to manage. So this was kind of a welcome change. But keep in mind, we do still have some requirements that you need to follow. So we have, and again, this is from Cal OSHA, these permanent COVID standards, and those are in effect through February of next year. So we still have about another year to deal with these. And then there are certain record keeping requirements. Again, you need to hold on to those records a little longer through February of 2026. You are still required to have a COVID prevention plan, or known as the CPP. If you haven't caught on, acronyms are a big thing in California. We love our acronyms. So you've got to make sure you've got your CPP in place. And that talks about implementing your workplace safety requirements. We do have a great toolkit out there for CEA members that you can access, but you're going to want to make sure you update your COVID prevention plan to reflect the new changes. Make sure it's up to date there. But here's another good thing that you don't have to worry about anymore. You might remember where you used to have to post a notice when somebody tested positive. You had to list the positive cases and you had to post that notice in a conspicuous place in the workplace. You don't have to do that anymore. You also no longer have to contact your workers' comp carrier anytime you have an employee test positive for COVID. That is gone as well. So take those off of your to-do list. You do still need to notify close contacts, or excuse me, contacts. So that could be, for example, you just send out a BCC email to people that would be considered a close contact and say, we've had somebody test positive in the workplace. Here's your information on what's defined as a close contact, and here are available resources to you. That's all part of your CPP. Now you can access all the information about this on the CDPH's website. Again, that's the California Department of Public Health. They have all the updated information out there. So I encourage you, take a look at that if you have any questions. But this is kind of a nice change for employers. It did start to lighten the load a little bit when it came to COVID. All right, so we are at the midway point and I am going to stop sharing so Juliana can share. And any other questions or anything we should wrap up in the first half before I turn it over to you?
Thank you. Yeah. So just some questions on when that business travel mileage and compensation kicks in and taking the commute out of it. So if you want to talk about that while I kind of transition.
Sure.
Yeah.
Absolutely. Yeah, so keep in mind an employee's normal commute, so their home to office commute, that is not compensable time. That's just considered commute time. As soon as they travel beyond that, so for example, if an employee's regular commute is 20 minutes and they travel 20 minutes from their home to their office, and you say, great, instead of coming to your regular office, I want you to go to this other office, it's 40 minutes away. Well, now your employee is 20 minutes above and beyond what they regularly drive. And so we need to pay them for that extra 20 minutes when it's above and beyond. Same thing if you send them out to do some errands. If their regular home to office commute is 20 minutes, but you say, you know what, this morning I want you to run to the bank and then I want you to swing by Starbucks and then can you pick up sandwiches for everybody on the way back? If that's 10 additional miles, then we need to make sure we're reimbursing them for 10 business miles. And of course, they're going to be on the clock for that time as well. So remember, exempt and non-exempt, we pay them back for their mileage. And our non-exempt employees, we need to make sure they're on the clock for that time. Our exempt employees are getting their flat salary all the time, so we don't have to worry about paying them anything extra except for that mileage. So did that clear it up, hopefully? I know.
Yes, it does. It does. Thank you, Mary. And I want to remind you guys, you can also call the hotline regarding your personal circumstances. If you want to flesh out a question or an issue, we can get you the best guidance. But Mary is now going to jump over to that Q&A box and continue answering questions. And I'm going to take over here. Mary did a fantastic job of covering a lot of dense and very important information. And she's already checked a lot off of our list. So that's the good news. In this second half, we're going to go over still some very important laws, but they may only come up as issues maybe from time to time. We're also going to go over some industry specific laws so we can take our foot off the gas a little bit in this next section. And we are now going to dive into some new employee protections, which we can always pretty much anticipate from the California legislature each year. And one of those big new ones has to do with cannabis under AB 2188. So I'm sure a lot of you have heard about this law, and I want to give you a little bit of history on where we were before 2024 with this, and that'll shed some light on where we're at now and why the status quo has changed. So prior to 2024, an employer could decide how they wanted to treat cannabis, and they might say, I don't even want somebody who uses cannabis at all in my workplace. And prior to 2024, that was okay, because even though cannabis had become legal for recreational purposes in California, it was still a federally controlled substance. So now that is changing for 2024 under AB 2188. The California legislature is saying we want employees to be protected in using cannabis in their 100% personal time when they are off the clock, when they're not on your work site. We don't think that that should be used against them. So they have created a new protected class under the Fair Employment and Housing Act. So for those of you that have maybe attended one of CEA's harassment prevention trainings, you know that in California, we have a very long list of protected classes. So some of the intuitive ones that come to mind: race, gender, religion, disability, the list goes on, and this is now adding to that. The practical result is that employers can no longer discriminate or take adverse action against an employee or applicant for using cannabis while off the job and away from the workplace. So again, in their 100% personal time. So if you were going through the hiring process and somebody just decided to share with you that they're a cannabis user, that could not be something that you use against them or decide not to hire them based on that. Or you could potentially have a discrimination lawsuit under the Fair Employment and Housing Act. But the law does not permit an employee to possess or be impaired by cannabis while on the job or while at your work site. So you can absolutely still have zero tolerance policies when it comes to your workplace, similar to alcohol, how we treat alcohol. Now, there's some exceptions to this law where employees would not get those protections to use cannabis in their personal time. One of the exceptions listed in the statute is employees in the building and construction trades. I think that's probably a result of good lobbying, and probably the argument being that these employees are working with very heavy machinery and equipment, and it could present a potential danger. Unfortunately, that term is not defined in the statute. We don't really have additional guidance on what that means. So if you are in the construction business and you also have an office worker, there's an argument that the office worker would still be able to use cannabis in their personal time. It's just not really clear what is meant by employees in the building and construction trades. So you might want to get additional guidance on that or err on the side of caution if you're not sure. And then also when testing is required by state or federal law. So this would mean that DOT regulated drivers would not have this protection. Federal contractors would not have this protection. All right, so we're not going to discriminate or take adverse action against somebody because they use cannabis in their personal time. This is also changing how we can drug test for cannabis. So remember, in California, when we can drug test is already pretty limited. It's typically going to be pre-employment screening for applicants, and then when we have reasonable suspicion that somebody's under the influence, so often after post-accident. Now, when we do test for cannabis now in 2024, we can no longer test for what is called the non-psychoactive components. So you may have heard that when somebody's taking a drug test, that it can come up, cannabis can come up on there, even if they've used it weeks ago or even a month ago. So that's the part that the legislature no longer wants, because they want employees to be able to use it in their personal time. You can only test now for active THC, indicating that somebody has used it or consumed it within the past few hours and that they might be under the influence of it. So really the only practical result here for employers, what do you really need to have on your radar for this? It's a good idea to reach out to your drug screening provider if you do drug test your employees, and just make sure that they have a plan for this, that you're on top of it. You could decide, well, maybe we'll just forego testing for cannabis. We're not going to worry about it. It's not a big concern in our industry. If you do that, make sure you're applying that policy consistently. Don't pick and choose who may be subject to a drug test or not, or you could be dealing with a discrimination issue there. Or you might say, we do want to continue to test for cannabis if we believe somebody's under the influence of it. In that case, your drug screening provider would just need to use a compliant testing method. So we are hearing that saliva would only pick up on that active THC that we're talking about, whereas a urine test is too sensitive, that it would pick up on those non-psychoactive components after somebody has already long metabolized cannabis. So talk to your drug screening provider. Hopefully they have a plan in place and you can decide how you want to move forward with that. If you need a drug screening provider, CEA's partner is OcuScreen, and they have a lot of expertise in this area. And so I'm sure they would be happy to assist you. All right, and the legislature has taken it one step further, and under SB 700 has also stated that it is going to be unlawful to request information from an applicant regarding their prior cannabis use. So we should not be even asking an applicant in the first place if they're a cannabis user, if they use it in their personal time. So you're going to add that to your list of no-nos for your...
Right. I think this is where she was at. Okay, I'll jump in here and then we'll get the lovely Julie.
Thank you, Mary. Thank you, everyone.
Thanks. Thanks, Anna.
Business as
Thanks
usual.
for hanging in there. Technology is fun. Okay, So as Juliana was saying, so it's unlawful to request information from an applicant about prior cannabis use, just like we can't ask about salary history, we can't ask about misdemeanors, felony convictions, those kind of things. Again, there's a little bit of an exception that if it's obtained as part of that criminal history, only when you're following those requirements of the Fair Chance Act, which we're going to talk about here in just a second. So probably familiar with the Fair Chance Act, that's been around for a little bit, but that's one way that you can get some information about cannabis use in the past. So here are your to-dos. So if you have tested your employees for cannabis, you've got to decide what you want to do, right? So this is am I going to stop testing for cannabis? Some employers have just decided to stop testing for cannabis. Are you going to talk to your provider, as Juliana was saying, to make sure they've got the saliva test? I just spoke with a hotline caller the other day that said, I just sent someone for a test and they realized the lab called them and said, you know what, we tested for marijuana with the urinalysis and we're kind of not doing that anymore. So what do you want to do with this information? And she said, don't tell me, because that's not going to be a compliant test. I'm going to send them back and do the saliva test because they wanted to have that as part of their process. So you're going to want to update your drug policies. You're going to want to make sure, as I was just, you might have saw in the Q&A box, I said to someone, we really do advise that you have a reasonable suspicion testing policy for your employees where you can test post-accident, where you can test just reasonable suspicion in general. Somebody comes in and they're acting erratically, or they're glassy-eyed, or they're talking to the plant in the corner, whatever they are doing, that you have that option of doing that reasonable suspicion testing. So, and that is in that sample employee handbook I told you that we have available on our store. So if you need that, that is all there for you. The other reminder is make sure you do train your managers on those new protections, especially if you have multiple locations. I know we've got a lot of people that are really big organizations on the call today, and sometimes that message doesn't always get sent down the line. So make sure everybody's on the same page with what those requirements and those guidelines are, so you don't have one manager kind of stepping out of hand there. All right. Non-compete agreements. So if you have been in California as a business owner for more than a day and a half, you probably know non-compete agreements have just been really whittled down in the past couple of years. And then this SB 699 really expanded the prohibition on non-compete agreements in general in California. So what they're saying now that employees, they really just don't hold water. And they are now saying that this is creating this private right of action for violations, including attorney's fees for prospective employees, current and former employees, if you had a non-compete agreement when you should not have had a non-compete agreement. So this is where audit your files, audit your paperwork, and make sure you don't have language regarding non-competes. Always consult with counsel. We always say that when it comes to arbitration. And certainly anything when it comes to non-competes, this is where you really want to consult with an attorney and work with them to make sure you are compliant with any of the language that you have in any of that paperwork and any of those agreements. So here's what they're saying you have to do now for non-competes. You actually have to provide what's known as this void notice. So anytime you had a written any sort of communication with current or former employees after January 1st of 2022, if you entered into a non-compete agreement with them or some sort of clause saying you had a non-compete agreement, you need to send them a letter saying that that is void, that that is no longer in effect. And happy Valentine's Day. What better way to celebrate with your Valentine or your Galentine? Send them a letter saying that that non-compete agreement is void. So you need to send that to their last known address and their email address. And this is just a little reminder, when you terminate or an employee leaves your employee, it's a great idea to ask them to write down their current address and their current email and their current phone number. Just in case something wacky like this comes up, you can get in touch with them. Or if you need to send them their W-2 or anything comes up, it's just good to have current information, because what you might have, it could be a year or two old, or maybe they say, oh yeah, I'm leaving and I'm moving to another state. So you want to make sure you just get that forwarding email and that address just in case you need to get a hold of them. So again, the violations for these, it could be an unfair competition claim. That means there's probably attorneys involved in a settlement, and we certainly don't want anyone to have to deal with that. The other big thing that came up is this new thing about retaliation. And this is something they kind of talked about putting in place, and boy, did they ever this year. So here's what they're saying is that there's going to be a presumption that you, the employer, engaged in unlawful retaliation if you take really any sort of adverse action against an employee within 90 days of them doing something that's protected. So for example, if they said to you, I don't think I'm paid fairly, you're not paying me enough, I'm underpaid because of this reason or that reason, and within 90 days you terminate that employee, there's going to be this automatic presumption that you did that in retaliation, unlawful retaliation for that. So you now, as the employer, will have the burden of proving that that's not why you had to make that employment decision, or why you had to terminate them or cut their pay or any of those adverse reactions. So here's what I would recommend. And if you call the hotline, I'm sure you've heard us say this before. Document, document, document. Anytime you have to cut hours, if you have to cut pay, if you have to demote, promote, good or bad, you really want to make sure you have a paper trail so that you can show you did this business reason for a legitimate business reason. It wasn't retaliatory. It was done because of XYZ, not because this employee made a complaint or brought up some sort of concern. So just be cautious with that, something to look out for in 2024. Again, it's just the burden is always on the employer, and I'm sorry, I wish it wasn't that way, but you do just need to do everything you can to kind of protect yourself from these things. So let's talk a little bit about some of those agency and regulatory updates that I mentioned before. And Juliana sent me a text and said she's so sorry, her total internet crashed. That's why she left us. But let's talk about Fair Chance Act. So as I mentioned before, remember, you want to make sure you audit your applications and audit your interview process to make sure people are not asking about salary information. They're not asking about criminal history. That includes arrest, misdemeanors, felony convictions, any of those things. And now we're not asking about cannabis use, right? You can only ask those questions post-offer pre-employment. So once you make a conditional offer, and you can say in that offer letter or that offer, verbal offer that you give them, we want to offer you this position. It's going to start this day, pending a successful background check or pre-employment drug screen. So that's how you want to do it. What you also need to remember when you get that background check information is you can only deny that job if there is that direct and adverse relationship to the duties that individual is going to perform for you. So this is why I recommend you want to make sure you have job descriptions that are very clear what an employee is going to be doing for you. And you say to that employee in the interview, I always say, it's great, give them a copy of the job description. That's really what you should be posting your ad based on your job description. When they come into interview, you give them a copy of the job description. And then if you get something back in that background check that's a big red flag, you want to make sure that you can show it has a direct and adverse relationship to the duties they're going to be doing. So for example, if you get a background check from an employee and you're hiring them to be a driver, and you find out 6 months ago they got a DUI or 3 months ago they got a DUI, well, that has a direct and adverse impact to that particular job. But if you're hiring someone to be a front receptionist who's just going to sit at your front desk and be lovely and answer the phone and greet customers, and you find out that he or she had a DUI a couple of years ago, probably doesn't have a direct and adverse relationship to their specific duties. So those are the things you want to take a look at. But what we have to know about this new kind of, again, everything's kind of expanded for 2024. This now applies not only to your external applicants, but this applies to employees who are looking to maybe get a promotion within the company. So internal positions, or if they just want to be considered for another position, or they're actually applying for another position. So be careful about not just automatically ruling someone out because you learn about something they did. You, again, have to make sure that it has a direct impact to their particular position. Also, keep this in mind if you are selling your business or maybe you're merging with another company. We want to make sure that that outside information doesn't influence any decisions you might be making unless it, again, has that direct and adverse impact. So here's a question that might come up. So my manager was having a casual conversation with Betty. who disclosed that she has a drug conviction. My manager does not want to consider her for a promotion now. Is that okay? Well, as we've all just learned, no. Just because she has a drug conviction doesn't automatically mean that we can't promote her into this position or take on this role. We have to exclude that from the situation because it doesn't have that direct and adverse impact. So we have to first consider her without the regard to that criminal history, even if it was voluntarily disclosed. Same thing happens a lot. I know for a lot of you that do interviews, people might just kind of just give up some information like I have 2 kids or I'm going through a divorce or whatever it is. And that's where you kind of have to bring it back and say, oh, okay, well, what we're really focused on are what are the objective factors of this job and are you qualified? Do you meet the qualifications? And you just have to put that information aside. Now, the other thing, as I mentioned before, you need to do that individual assessment to see if it has that direct and adverse impact. Now, employees, if they're applying for an internal position or an employee who's just applying for your company in general, they have the opportunity to provide some evidence that's challenging to that conviction. So what they might be able to give to you is perhaps it's a police report where they can say, well, yes, I was convicted of assault, but it was because I was in this abusive relationship. Or maybe they can show, well, yes, I had a DUI, but I've been sober for 2 years. I go to AA meetings every week. Here's a copy of my rehabilitation program I was in. So they now have an opportunity to present that information to you. Keep in mind, you can't require this. So you can't say, you have to give me something that refutes this. You just give them the opportunity if they would like to provide that or if they volunteer to provide that information to you. And for CEA members, we do have a fact sheet on this that you can access on the website. You may not be dealing with this too much, but it is something that might come up that you've got to be prepared to deal with. All right, it's time to talk about more acronyms. That's why I kicked Juliana off because I wanted to talk about all the acronyms today. And we're now going to talk about the NLRA, which is the National Labor Relations Act, which is managed by the NLRB, the National Labor Relations Board. Now, a lot of times when people hear this, they think, oh, that's union. I'm not union. I don't need to worry about it. Well, that's kind of a misconception because Section 7 of the NLRA, it talks about just general employee protections. And as you probably know, there has been a lot more emphasis or attention paid to unions lately with our current administration. They're very pro-labor, pro-union. And so that's why we've been hearing more about these things. Section 7 gives employees the right to talk about wages, the hours that they work, terms and conditions of employment, et cetera. So that means you can't say to your employees, you are not allowed to tell anybody how much you make. You can't talk to anybody about what it's like to work here. That's simply not allowed in California. You can't do that. And this is actually a national thing, but of course, California keeps an eye on it, I think a little more closely than some other states, but NLRA does apply to absolutely everybody. So there have been some recent cases that have kind of brought a little more attention to this. And they really have come out and said, all right, if you as an employer do anything to chill employees' rights or chill employees' exercise of their rights, then you are doing something that is unlawful. So again, that term chill, if you're saying don't talk about this or probably not in your best interest to talk about this, you are essentially chilling your employees' rights to discuss those things. Now, again, if you can show that there was some sort of legitimate business reason why you told employees they couldn't talk about these things, then you can be protected. But again, you've got to make sure you take a step back and you're very objective to say, well, this is why we can't talk about this, or this is proprietary information. Eli from our team wrote a great article about this, and you can access that on our website. I believe it's under our blog as well. It was in our newsletter. And we did address these in our handbook. So make sure you, if you need that handbook, it's out there for you. Take a look at it and we'll get you all set up with that, or read that article if you need a little more clarification. But here's how subtle it can be. If you just say to your employees, don't discuss how we do things at our company with anyone, well, that is unlawful. You can't say that. But what you could say is, don't disclose confidential financial information or non-public proprietary company information. So you see that distinction where it's something that's specific to the company that people can't know. Proprietary information is just yours to have. Don't share confidential information with regarding business partners, vendors, or customers. So that's the difference. And some of the handbooks that you might have just might be a little outdated with that language. So that's why we recommend to make sure you get some up-to-date language with that. So here are your to-dos for this section. Make sure you audit your job applications, your interview questions. Again, talk with managers, different managers that might do training for you, just to make sure everybody is on the same page. You also audit that employee handbook and your policies to make sure you are up to date with that new NLRB standard. And again, our 2024 handbook is ready to go for you. All right, couple more industry updates to get to, and then I noticed we've got some questions in the Q&A box, so I will jump and answer those here at the end. Couple of industry-specific updates for those of you that have teenagers in the fast food world, as I do. This was happy news for some, not as happy news for others, but there is this, and I'm sure you've been hearing about this for a couple of years. There was that FAST Act. It was the Fast Food FAST Act that was going around. It was kind of around, and then it was repealed, and then it was held up, and then it was going to be a proposition on the ballot this fall. That is all gone now. And what we have now is this Fast Food Council, and that is under the DIR, which is the Department of Industrial Relations. And they have put together these new minimum wage and working guidelines for 2024 that are in effect, and they are going to be in effect until 2029. So what they have set up is this new 20-hour minimum wage requirement that goes into effect as of April 1st of 2024. Now, I don't know about you, but I have a couple of kids who are in fast food and friends that work at different fast food chains, and some of them have already put this into place, but it doesn't necessarily apply to everyone. So let me show you kind of the breakdown here. So who this applies to are chains that have more than 60 establishments nationwide. So, and they call these limited service restaurants. So what does that mean? Well, that is somebody who's providing food and beverages for immediate consumption, right? You order at the counter, you go sit down and eat, or you drive off through the drive-through with it. These are individuals that you order something and you pay before consuming, so it's not really that sit-down table service. There are a couple of exceptions in place for this when it comes to bakeries and grocery stores, and just like we've been talking about today, there's always a couple of exceptions. If you are unsure if this applies to you, definitely recommend consult with legal counsel. Make sure you're being compliant and staying up to date with that. What I can tell you is a couple of major chains in our area. I'm just outside of Sacramento. They have already put this into place. So they are already paying their employees $20 an hour. So we'll see if some others kind of jump in a little early too, just to stay competitive with this. But there are a couple of open-ended questions. So what does that mean, primarily engaged? We're hoping we'll get some more clarification from the fast food board on that. Now, this is that one that I mentioned before. So when we're looking at an exempt employee salary, we normally just look at that state requirement to find out if we're paying our exempt employees enough. But the question has come up, are covered exempt employees entitled to an annual salary of 2 times the minimum wage for these fast food restaurants? We likely think yes. We think it will probably be a little higher. So then you're looking at your exempt managers or administrative people in a fast food chain making at least $83,200. So you'll probably have some people who are changing their employees from exempt to non-exempt in the fast food industry as well. We're also trying to find out, what about businesses that work inside another business? So a Starbucks inside of a Target, for example. How is it going to apply to them? And again, will this affect other businesses going up to this 20-hour minimum wage? I know one of my kids works at a chain, but they only have about 8 restaurants. They are not planning on going to $20 an hour, excuse me. They're just going to stick with the $16 an hour. So we'll see if it changes or how this really affects other businesses in general. And I'm sure we'll have some more information on this. So again, stay tuned. Make sure you're getting our newsletter and reading our emails that we send out. The other thing that comes into play here are food handler cards. So if you are in the food industry, you know, in the past, it wasn't completely clear if you were paying for a food handler card, if you had to, it was best practice. Well, now it's very clear. So as of January 1st of this year, you as the business need to make sure that you are paying for your employees to have a food handler card if they don't have one. They do need to have that within 30 days of hire. It's good for 3 years. There's online classes that they can take for it. It is not a lot of time, but keep in mind that you are going to be responsible for all of those costs. So you need to pay for them to be on the clock when they are taking that class, and you pay for them while they are taking that test, and then you pay for the cost of that test as well if that individual doesn't have a current card. So again, make sure they're on the clock, make sure you're paying for that test. And again, it's really just in your best interest because you want to make sure everybody has an up-to-date and valid food handler card when they're working for you. So this was something that was a little unclear, but now they have clarified it for 2024. And I see that Juliana is back. Welcome back, Juliana, talking about food handler cards. So make sure you update your policies, your hiring, your onboarding practices, so all of your employees are on the same page, and all your managers that might be in charge of this as well. So make sure that they don't say to an applicant, well, you have to have a food handler card before you come work for us. You don't want to say that anymore. What you say is, if you don't have a food handler card, we will be happy to make sure you get that training and pay for that. All right, Juliana is back. Welcome back.
Can I just pop in really quickly?
Yes, of course.
I put this into the chat, but just in case some of our attendees today didn't catch it in the chat, we do have Jessica Hawthorne, our Senior Vice President, here with us. We welcome back, Gigi. Thank you for joining us. Sorry again about the little glitch there, everybody. In case your question that you put into the Q&A was still outstanding, if you have the ability, can you please put that back in the Q&A so that two of our trainers can try and make sure that gets addressed in the next few minutes. Thank you.
Thank you, team, and I apologize for that glitch. And I know Mary was probably a rock star in taking over there. So Mary, would you prefer I take over here or hop over to the Q&A?
I can go ahead. We've just got a couple more. If you want to catch up on Q&A, that would be great, because then we'll give us
right.
to chat.
Thank you.
All right, so here's another one that's interesting. You might have heard about this too. I think we have a couple of businesses on in the healthcare world. So they were talking about this big healthcare minimum wage change that was going to go into effect June 1st of 2024. But this looks like it's going to be delayed. So the governor has said he's planning on delaying this, but we haven't had official confirmation. So that's why we still wanted to let you know about it. But if you have employees that are in this covered healthcare industry, which sometimes that's why this is also gets a little confusing, because sometimes they use healthcare in really general terms. So for example, sometimes it includes dentists. In this particular wage or Senate bill, it does not. But this is something just to keep an eye on if you are in part of that healthcare, that they've been talking about increasing that minimum wage from $18 to $23 an hour. There are going to be future increases. It's done on kind of the sliding scale. It's pretty involved and confusing. So I was not sad when I heard that this was going to be delayed a little bit. But this is something that we do recommend you consult with counsel to see if this applies to you and how you will implement it if this does indeed move forward. But it looks like it's going to be delayed right now, but stay tuned. We'll keep you up to date, and hopefully we'll get some more clarification about how you want to implement this, especially when it comes to your exempt employees, because there's kind of this fancy calculation of 1.5 times the healthcare minimum wage or 2 times the local minimum wage, and it's a little confusing. So I think they're going to work out some of the little issues in this before it becomes final, but we'll certainly keep you up to date on that. A couple of other things, just to wrap it up. I know we have several groups with us that are kind of in the hospitality industry, so I know you're familiar with the right of recall. That is still in effect right now, and that is in effect until December 31st, 2025. We'll see if that changes, but that is the new expiration date. That applies to hotels, private clubs, event centers, airport hospitality and service providers, some building services as well. So make sure you're staying up to date if you fall into those categories. And then another thing they have been proposing for quite a while is this indoor heat illness standard. For those of you that have employees out in the field, you're probably very familiar with the outdoor heat illness standard. Certainly in Riverside County, you have to deal with this as well. Up in Sacramento, we get quite toasty up here. And there is some outdoor heat illness standards when it's 82 degrees and above. they're talking about that for indoor heat illness as well. So if you have a facility, maybe it's a large warehouse where there's always a door open, for example, you might have to be following some of these indoor heat illness standards. Nothing is final yet. It's just something they've talked about, and they seem to be getting a little closer. So we don't have a proposed implementation date, probably wouldn't be till summer. We should have some more information though here in the first quarter in the next couple of months. So that's just another one to stay tuned to. All right, well, I know that was a lot of information, and thanks again, everyone, for hanging in there with our internet tech issues. You know, that's just how life is. That's just how it goes. But here is your hotline number. It is 888-201-5950. Feel free to give us a call anytime you have questions on anything we've talked about today. Later on, when you think, oh gosh, I wish I'd asked that, or something just comes up you hadn't even planned on. If it was about this or anything else we can help you with, again, breaks, lunches, harassment prevention, discrimination concerns, hiring and firing best practices, we are happy to help you. And I want to put up the codes, and then I thought we could open it back up to see if there were any Q&A questions that everyone might want to hear the answer to, but your HRCI codes for today. So if you're an HR professional, if you have your PHR or SPHR from either SHRM or HRCI, your HRCI number 651640, that is your code, and SHRM is 24-NSKYK. So make sure, as you probably know, got to make sure you're recertifying every 3 years or so. So you certainly deserve an hour and a half of credit for listening to all the new labor law updates. And as I mentioned before, we do have individual memberships if you find you need a little help outside of the hotline, or if you just want to have full access to our website and all of the forms and toolkits that Juliana and I chatted about today. And we actually have a monthly membership if you just want to try us out for a couple of months and see what you think. But there's Associate, Premier, and Ultimate. Lots of good benefits with each of those. So feel free, you can give us a call at the hotline and we can put you in touch with one of our service team members who can give you some more info on that if you find you need a little more help. All right, and with that, I will bring up the slide and turn it back over to Anna for a moment so she can talk about our survey, and then I'll jump in and see if there's any questions that we still need to answer too. Thanks, Anna. And you are muted, my friend.
You would think with all the webinars I have hosted, I would remember to unmute myself. We are just doing great technological, some things in retrograde right now, right? Q&A is not accepting questions. How much is the handbook? Let me drop that link in the chat shortly, or I'll follow up with email for you, because we do have a couple of options with both a DIY handbook template as well as a kind of done for you, a little more high touch service. So I'll follow up with you about those, Tracy. I will make sure I find that for you. But other than that, I know we do have a few more minutes. So if anyone does have any outstanding questions, we are lucky to now have 3 expert trainers with us. So this is the time to take advantage of it and not, you know, have to call in. Not that that's not an amazing service, but this is like real time answers. So while I get the information for that, as well as the link for our next training, anyone has any additional questions, this is the time.
Yeah, I can still see a couple of questions in my Q&A, and I don't think they've been answered. Let's see, we had a question. What if a client requires our employees to be cannabis free when they enter the client site? So the same rules kind of apply, that your employees should be following your drug and alcohol free workplace policy. And that's how we recommend you think of cannabis. It's just like drugs and alcohol. They can't be under the influence when they are working for you. So that's why we recommend you've got your drug and alcohol free workplace policy, and you also have a reasonable suspicion testing policy. So in the event you need to test your employees, if they are at your location or if they're at another location, we do always recommend that you want to have a manager do an assessment to see if somebody is under the influence. But you could certainly, if a client has a concern, they could contact you and then you could do an assessment. So you've got a couple of different options there. Did someone else want to jump in with another one?
Well, the reason I'm jumping in is I did answer a lot of those questions. So
Okay.
I just want to make sure we weren't super overlapping. And we did get a number of questions about discussing wages in the workplace, when that's disruptive, and some people have been there for a long time, and so maybe they may earn more money, things like that. And unfortunately, under our labor code in California and under NLRA, we can't tell employees not to discuss those things. However, we can do training for employees on professionalism. If you have a lot of extra free time, we can give you extra job duties, but never prohibit employees from talking about wages, because both federal and state might get you in trouble. And we just did get a new question that popped in about, are we required to post human trafficking in our workplace? I'm assuming that human trafficking notification poster, and that's only for certain locations like airports, the hospitality industry. So if you're that type of employer, yes, but it's not considered an employer required posting, such as minimum wage, things like that.
We also got a really interesting question going back to the cannabis for an on-call employee and how you could apply that. And I think that can present some interesting issues. I think if they're in a paid on-call status, then it's very clearly working time. And so you can say you can't be under the influence of it. But how would that work if somebody is just on call? You know, we'll call you up if we have some work. You know, maybe you have them sign something that they're not going to come to work under the influence of cannabis in that case, if they're in more of an on-call capacity. But Jessica, do you have Mary, other thoughts on that? That's an interesting one.
Yeah, because you can't prohibit them from doing anything, but you can still enforce your policy of not being under the influence at work. So if you're on call and we call you and you're under the influence, your best answer would be, I am not available today, because it'll probably get you in a little bit of trouble. We just got another question. We pay a shift differential for our graveyard shift. Is there a law that says we have to pay it at $1 for all hours worked? I think we're talking about split shift, or are we paying an additional fee for working the overnight shift? Give the hotline a call so we can make sure we're getting all the nuances of your question, because we want to make sure we give you the right information based on your actual circumstance. All right.
Cool.
Thank
So
you.
in the meantime, I did drop a link into the chat for our next training with Riverside County. Again, this is free to all Riverside employers like yourself. So we really encourage you to sign up. That is coming up on February 13th. And it's a 2024 wage and hour update. So that's going to be an entire training specifically on all of those nuanced updates and laws and whatnot. So again, bring your questions. And I also did drop a link to the chat to our employee handbook information. And so if there are no other questions, then again, I want to thank you all for joining us live. Thank you for your patience with us. As you know, it's going to have, oh, can the link be emailed? Yes, for sure. I will follow up with everybody with the final handouts and with a link to the employee handbook resource. I'm more than happy to do that just after we finish this call. So thank you again to Jason and the entire Riverside County team. Thank you to our suite of trainers today for sharing your expertise and your time with us. And thank you all for joining us live. And we really look forward to seeing you on February 13th. Cheers.